Crime is wickedness. Crime is greed. Crime destroys families. Crime divides nations.
That is the law. So it mustn't be argued that this judge didn't consider the evidence regarding coercion. In other words, the synopsis of the encapsulation of the evidence, the salient features are this: that when the state intended to bring into play by introducing the so-called alleged confessions or statements of accused number 1 and 2 and the pointing out by accused number 2, the defense objected. And the principal objection was that, 1, they did not make statements. They did not make confessions. They were told to sign documents which were fully completed, and they were told sign here, sign there, initial here, initial there. That was the initial defense. The second defense is that they were assaulted, tortured, severely, as Mr. Mugomezulu put it, severely tortured, choked, electrocuted, kicked, in order to elicit their signatures on the documents. In other words, these accused before court, their evidence is they don't know the contents of the confession. They don't know. They were never read to them. If you go further, accused number 1, for instance, says when he went to sign the confession or statements before Maboto, I think, Maboto never even sat down. When Maboto came, they were assaulting him. All that group of policemen. And Maboto then called him aside and said, hey, you know what? Why don't you sign this document? These guys are going to injure you. And then, to save his life, accused number 1 says he signed. No discussion with Maboto in an office sitting down, according to accused number 1. Accused number 2 also says when he went to sign the alleged confession or statement before Mrs. Konje, all he said when he got in, even before Mrs. Konje could introduce herself as a magistrate, he came in and told Mrs. Matlapin, the interpreter, that may you tell the lady please that 6 weeks I haven't had a bath from the 16th of June, I think, and also that I want to speak to my daughter, I want to speak to my partner or parents. And that was it. And he sat down and looked at the ground. And Mrs. Konje, what he did was, he was busy with his computer. She never asked him anything. All she was interested in was the computer, and then she would get out and gossip with a fellow magistrate or fellow white lady and come back. Mohoro was going in and out, consulting with Mrs. Konje. Nothing was discussed between accused number 1 and number 2 and Mrs. Konje, except, as I said, that I haven't had a bath and I want to speak to my daughter and my partner. Nothing. The same applies for Rapudu. Accused number 2 says, no discussion with Rapudu, nothing. He was just written up and told to sign. So in the game, that is the salient aspects of the evidence relating to the trial within the trial. It's obvious that Kilinda, Naholewa and others gave evidence. But what I want us to understand is that this court, after careful analysis of the evidence adduced by the state, and after careful analysis of the cross-examination interposed by the defense against the evidence adduced by the state, and after careful analysis of the rebuttal evidence of accused number 1 and 2, and the cross-examination interposed by the state. And after careful analysis of the heads of argument by all the parties concerned and the verbal submissions made by all the counsels in this court, I have dealt, not like this magistrate did, I've dealt with all the evidence relating to whether the said alleged confessions were made freely and voluntarily in the sound and sober senses of the deponents without any force or coercion. I've dealt with all that, and I've also dealt with the other primary defense by the accused, that all the accused were not apprised of their constitutional rights, meaning section 35(5) of their rights. They were never apprised according to that. And this court even also interrogated that. And as we all know, section 35 encapsulates the concept that if any evidence is acquired through the infringement of the Bill of Rights, that evidence should not be admitted into the record of the proceedings relating to section 1(7) and section 1(8), even section 1(9) of the Criminal Procedure Act. Right. Consequently, after going through all that evidence carefully, this court has reached the following conclusion. One, it rules that the confession made by accused number 1 was made freely and voluntarily without any coercion when accused number 1 was in his firm, sound, and sober senses. 2, the confession made by accused number 2 in respect of the said confession being taken by Mrs. Ronje, the magistrate, the court rules that it was made freely and voluntarily without any coercion when accused number 2 was in his full and sober senses. And also the confession made before Colonel Rapudi was also made by accused number 1, 2. Freely and voluntarily without any coercion when he was in his sound and sober senses. And also the pointing out made by accused number 2 before Colonel Khadebe were also made freely and voluntarily without any coercion when accused number 2 was in his full and sober senses. Okay, that is the ruling.
Okay.